The burden of proof is a very important term that we use in what I do for a living, and it's important because most people's familiarity with the jury system typically has to do with criminal law. And the criminal burden of proof, as most people know, is beyond a reasonable doubt. That's the standard that a prosecutor has to meet in order to get someone convicted. And the reason for that is because our founding fathers set up a system, and a lot of people are unhappy with it. That's the bottom line intent of that system is a belief that it's better for 10 guilty people to go free than one innocent person to go to jail. Now, the burden of proof in a civil case where you're suing, for example, for a personal injury is significantly different. It's more probable than not, or more likely true than not true. So in a criminal system, if the burden of proof is beyond a reasonable doubt using the scales of justice, this is the burden that a prosecutor has. In a civil case, more likely true than not true, the burden's on the plaintiff, the people who I represent. More likely true than not true simply means 50.5% as opposed to 49.5%. It's a very slight difference. And it's important for people to understand that, because basically what it means in a civil case, because no one's going to jail, that you can have doubts, but you're told at the end of the day that when you weigh the evidence, if the evidence tips slightly in one way, that's more likely true than not true, and that's the burden. And typically we hear people, and we really try to explain this to them during jury trials, because you hear people say, I don't think he's guilty, or I have a doubt. But in the civil system, you can have doubts as long as you ultimately, in weighing all the evidence, make the determination that something is more likely true than not true. That's the difference.